All right, so you want to go out and raise some capital, and you've seen people on Instagram or Facebook posting their private investment offering publicly. So you're wondering, okay, I want to do that. The most common way is under Rule 506C in securities law. As a securities attorney, I get tons of questions about the process and what do I have to do to be able to do that? So in order to publicly put it out there to generally solicit, advertise, to bring in capital, under 506C, you have to make sure that all of your investors are what's considered accredited. So I'm going to go through some of the common questions that I get as a securities attorney and just some of an overview of the process to verify that people are accredited. So let me share my screen. And then I will go over. Okay, so accredited verification under 506C. So Rule 506C is in Regulation D. It allows you to raise an unlimited amount of money, essentially with an unlimited number of investors, as long as they're all accredited. Accredited is a term that's defined under Rule 501, which is within Reg D, basically, under securities law. The most common ones are, there's about 13 or more different definitions, but some of the more common ones generally are if you have like an entity, an LLC, a corporation, a trust, over $5 million in assets that was not formed for the particular purpose of this investment. So if you've got an existing LLC, has over 5 million in assets, that can be an accredited investor. Generally, if it's an individual, as long as they've been making $200,000 or more in the last 2 years and an expectation to make that amount going forward in the next year for an individual, or over 300,000 for a married couple for the last 2 years and an expectation to continue. Also, if they have over $1 million in net worth, which cannot include their primary residence, their home, or the mortgage on it. So kind of outside of their home, their other assets and net worth have to be over $1 million. And also the SEC does look through basically an entity, which is a common question I get. Hey, I got a group of investors. We're not accredited, but we're going to form an LLC and put our money together, pool it together, and make this LLC be the accredited investor. No, it doesn't work that way. So unless the LLC was already existing with over 5 million in assets and was not formed for the particular purpose of this investment, it could be accredited. However, if you go out and start a new LLC just to invest, that doesn't work. And the SEC is going to look through the LLC to the individual members or owners of the LLC, and all of those individual members have to be accredited. So you have to go through the process of verifying every single individual within that LLC. Otherwise, you haven't done what you're required to do. Now, 506C allows general solicitation and advertising. That means that you can go out to anybody on the street, you can post on Instagram, you can post, anywhere publicly to advertise for the private placement. Now, I will give the disclaimer that just because you can post anywhere, it doesn't mean you can say whatever you want. There are still anti-fraud rules and some other rules that you have to worry about. So it's always best to go over what ads you're going to be doing with someone who is experienced in this area. You also have to take steps to verify that they are accredited. That's one of the requirements to qualify for the exemption under 506C. So how and when do we verify? You have to verify before they put their money in. So you want to make sure that you've done your due diligence and you've taken your steps to verify they're accredited before you accept their investment. You accept their subscription agreement, accept their money, you better make sure you've already verified them before then. So the issuer, which is the company selling money and issuing a security, must actively verify the status of an investor, and all have to be accredited. And they have to take reasonable steps, which is what the SEC rule says. Also, if you have knowledge that somebody is not accredited, and even if you kind of take steps to make them seem accredited, if the issuer is shown to have known that they really aren't accredited, then you're going to lose this exemption. Now, some people will use a third party. There are a number of services out there online that will do third-party verification of your investors for you. Now, that's, as long as you're going with a reputable company, it's not necessarily anything wrong with that, but you have to understand that the rule applies to the issuer, meaning the company issuing the security, and that is the person or individual within that company has to take the steps. So you can't say, well, I hired a third party, they didn't do their job. The liability ultimately is going to fall on the executive officers of the issuer. So if you use a third party, understand that you better do your due diligence on them and make sure they're actually doing what they say they are to verify under the terms of the rule. Otherwise, you can do it yourself, which is essentially what the rule says. One of the methods, the SEC hasn't said these are the only methods. It's given some explanations of examples on how you can verify your investors. One of those is getting a written letter from certain people that would basically say, hey, I'm so-and-so. I know this person who's an investor potentially in your deal. They are accredited under, Rule 501, the definition of an accredited investor, and I certify or verify that for you. Has to be dated within 3 months, the last 3 months before their investment. And the list of who can do that is a CPA, and these all have to be licensed or registered. A CPA, a registered investment advisor, a licensed attorney, or a registered or licensed broker-dealer, securities broker. The other thing that you can do is get backup documentation to verify that they are accredited. Now, what does that exactly mean? So if someone comes in saying, I'm accredited because I meet the income test, I have over $200,000 a year in income. Well, we want to see your W-2s, any K-1s, your tax returns for the last 2 years at least, to verify that you actually have earned $200,000 or more in income. Or if you're a couple, married couple, then it's $300,000 or more in income. If you're going by the net worth test, you want to see copies of bank statements, maybe credit reports, debt statements like a mortgage statement to verify that they actually have over $1 million in net worth. Now we get this question a lot also. Basically, we put together a bunch of deals, we raise capital for all these different types of deals, and one of our investors, we verified them in a couple deals before, so we know they're accredited and they've been verified. So we have a new deal and we want to put them into that. Do we have to verify them again? Yes. So the rule says that anything within the last 5 years, if someone's already been accredited or verified as accredited within the last 5 years, you may not have to verify them again. However, the rule says the issuer, meaning the actual issuer of that security. So if somebody, for example, was an investor in company A and company A raises money again 6 months, a year down the road, and they were already verified with company A, then they're fine with company A. But when you start another new company, that's a new issuer of a security, and that's company B. So they can't take company A's verification and use it for company B, even maybe the same executive officers, all the same people are involved. It's technically a different issuer. It would make sense that you could, but technically that's not what the way the rule is written. So unless there's some guidance from the SEC that comes out that says you can apply it to other issuers, right now the way the rule says is the same issuer. So some of the resources that you can find online, you can obviously talk to a corporate or securities attorney, such as myself, to ask questions about this, but you can also find a lot of information online as long as you go to the right places. So you want to go to places like sec.gov, investor.gov. These are both run basically by the federal government, and they put out pretty decent information. And let me switch over just quickly to show you their websites that have this. So this is sec.gov, like for example, 506C. Boom, it talks about general solicitation. There's parts on here about verification. You can also go to investor.gov, which is actually run by the SEC, and it provides pretty good self-explanatory information about things like Rule 506B, Rule 506C. So this is stuff that you can find publicly available, but you want to make sure that you're going to, basically someone who is an authorized person, like a governmental entity like the SEC, to make sure you're getting quality information. Thanks.